Hello class, welcome back. We will use this discussion to focus on intentional torts. Let us get started. Most torts are not intentional, they are accidents. The legal term for an accident is negligence. To determine whether someone is liable for negligence, one must analyze the following questions. Did the defendant owe a duty of care to the plaintiff? Did the defendant breach that duty? Did the plaintiff suffer a legally recognizable injury? And did the defendant breach of duty cause the harm? In general, we owe all people the duty to exercise the care that a reasonably prudent person would exercise under the circumstances to prevent foreseeable harms to others. In establishing the existence of a duty, use the reasonable person standards. You will want to ask what standard of behavior is expected of a reasonable person in these circumstances. For example, a grocery store has a high duty towards its customers. Professionals, such as physicians, have a high duty of care to their parents. These duties vary depending upon the situation. Other examples of these duties are the duty not to create conditions that are dangerous to the public, and the duty to contain wild animals we may own. In the context of a car accident case, all drivers have a legal duty to act with reasonable care in the operation of their vehicles. One must also ask whether the defendant breached the duty. A bad outcome is not necessarily a breach. What if Sally slips on a broken mustard jar in the grocery store? Did the grocery store breach its duty? Well, what if they checked the aisles every 15 minutes and this occurred between checks? Or what if they check it every 2 hours? It is up to a jury to decide what is reasonable. Just know that conduct that is unreasonable or irresponsible under the circumstances amounts to a breach of the legal duty of care discussed. So, if a driver of a car runs a red light and hits another car, that driver has failed to drive in a reasonably responsible manner and has breached his or her legal duty of care. Finally, defendants must have actually caused the harm. Causation is pretty clear in most cases. Basically, the defendant's conduct must have led directly to the harm suffered by the plaintiff. A big one is causation. Did the defendant's conduct contribute to the plaintiff's harm? There are several tests that courts use to analyze causation. One is the but-for test, in which you ask, but for the plaintiff's conduct, would the harm have occurred? This test can be useful, but has its weaknesses as well. If I am driving a car and someone hits me from behind, and I slammed into Sue's mailbox, but for my driving the car, Sue's mailbox would not have been damaged. There is also another way to analyze causation, that is, proximate cause. Proximate cause means that there was a strong connection between the act and the injury. Foreseeability is also important. The harm must have been foreseeable. An example is a case called the Palsgraf case, which is a classical example. A man was holding a package and was trying to get on a train that was moving. The railroad guard pushed him up and he dropped his package on the platform. The package contained fireworks, which exploded and injured a lady on the other side of the station. While the guard breached his duty, the court held that the station was not liable for the harm because the injury was not foreseeable. It was not reasonable to believe that pushing a man on a train would result in an injury to someone on the other side of the station. The plaintiff must have suffered a legally recognizable injury. This means that the plaintiff must have an injury as a result of the thing the defendant did. For example, if you are involved in a car accident and fractured your ankle as a direct result of the car accident, that fracture would be your legally recognizable injury. On the other hand, if you got into a car accident and already had a fracture, which may have been caused by falling on your stairs at home, that fracture is not considered a legally recognizable injury in this situation. It is an injury, yes, but not one caused as a result of the accident for which you are suing the defendant. There are several defenses to negligence. The first is assumption of risk. Some activities are risky and cannot be mitigated. If you participate in these activities, you assume that risk. For example, if you hike in a national park and slip on a rock, you cannot sue the federal government since you knew the inherent risk when you hiked. A superseding cause is something that happens between the breach of duty and the injury to cause the harm. Assume that Albert rear-ends Sally's car. As Sally is waiting on the side of the road, a truck comes along and hits her. Albert is liable for the injuries he caused to Sally, but not liable for the injuries the truck caused, even though she wouldn't have been in the position to be hit by the truck but for Albert. Often, the plaintiff is partially at fault in an accident. Under the doctrine of contributory negligence, any fault of the plaintiff is a complete bar of recovery. Under comparative negligence, fault is apportioned between the parties. Thus, if the defendant is 80% at fault and the plaintiff is 20%, the defendant is responsible for 80% of the damages. The plaintiff would be responsible for 20% of the defendant's damages. However, if the defendant, who is 80% at fault, had an expensive car and suffers $50,000 in damages, while the plaintiff, who was 20% at fault, had a cheap car and suffered $1,000 in damages, in this case, the plaintiff would owe 20% of the $50,000, which is $1,000, and would receive 80% of the $1,000, which is $800. To cure this inequity, most states and jurisdictions have enacted a 50% rule, in which, if you were more than 50% at fault, you recover nothing. So under the 50% rule, the plaintiff would collect 80% of her damages, but would be responsible for none of the defendants. Sometimes it is difficult to prove a case with direct evidence. For example, if you undergo surgery for an operation on your left arm and wake up with scars on both arms, how do you prove that the scar on your right arm was caused by the physician? Well, this is where the doctrine of res ipsa loquitur comes in. It means the thing speaks for itself. In the situation, if the situation was under the exclusive control of the defendant and the injuries could have happened no other way, that is sufficient proof. Some acts, or failures to act, that violate a statute are negligence per se. It does not matter if you breach a duty. If you did the act, you are negligent. Under danger invites rescue. If someone is injured trying to rescue another, the person who caused the original harm is liable. So if Sam runs Sally off the road into a river and Cat tries to save Sally, Sam is liable for damages that Cat incurs in rescuing Sally. Strict liability is liability regardless of fault. If you engage in certain activities, you will be liable for any damages, no matter how careful you were. The reasoning is that some activities are so dangerous that the person must be held liable. Examples would be abnormally dangerous activities like strong dynamite at home, transporting radioactive waste, and harboring wild animals. For example, if your pet rattlesnake escapes, you are liable. This also applies to domestic animals with known dangerous tendencies, such as dogs that one knows or knew are prone to attack. There have been several attempts at holding Internet service providers responsible for the content that they carry, but they have failed. In one case, a member of former President Clinton's staff sued Drudge, the Drudge Report, for defamation regarding something he posted on his website. That person also sued America Online, who at that time was the host for the Drudge Report. The suit against AOL was dismissed. This is the end of this presentation. Thank you for listening and have a wonderful week.